So Oregon Measure 114's firearms purchase permit and magazine ban have been blocked once again from going into effect. So let's talk about this. But real quick before we jump into this video, I want to thank one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. Also, I want to mention that the Gundy's voting is currently open. I don't know if you recall, but last year we won the award for Top 2A Voices. I'm in the same category once again this year, and I would love to win. You can vote every single day on their website. There's 15 different categories. I'm in the Top 2A Voices, and the Gundy's Awards is giving away prizes. And also one of the grand prizes that they have is that if you are in there, if you're voting every single day, you're entered to win a free trip to the event with all of us. So again, thank you guys for all of your support, and I would really appreciate your vote. As I mentioned in the intro, in this video, we will be discussing the current challenges to Oregon Measure 114, which was originally set to go into effect on December 8th. This measure, which passed in the state of Oregon, creates a purchase permit that Oregon residents must obtain to be able to purchase any firearms, and also it creates a ban on so-called large capacity magazines. In response to Measure 114, the state has now been sued in multiple cases. The two cases we will be focusing on in this video are called Arnold v. Brown and also OFF v. Brown. The Arnold case is a state lawsuit filed by Gun Owners of America, and it challenges Oregon Measure 114 as a violation of the Oregon State Constitution. The OFF case is a lawsuit in a federal court and challenges the Measure 114 under a violation of the Second Amendment, again, of the U.S. Constitution. Now, for those not familiar with what Oregon Measure 114 does, let me explain generally what is going on. First, Oregon Measure 114 generally creates a permit to purchase, where you have to have this permit to purchase to be able to obtain any firearms going forward after the law goes into effect. To obtain the permit to purchase, the resident will need to complete a safety training course, go through a background check system, get fingerprinted, show a valid ID, and then after all that, eventually you will be granted a permit to purchase. However, Measure 114 did not stop with just creating a permit to purchase. The second significant thing that the measure does is it creates a ban on the sale, purchase, transfer, and possession of all so-called large capacity magazines. And again, when it goes into effect, there would be a ban on magazines that hold more than 10 rounds, along with other types of magazines as well, like belts, drums, feed strips, coupled magazines, and other items as well. This measure makes a violation of the law a Class A misdemeanor, which is punishable of up to 364 days in jail and or a fine of $6,250. And again, it applies to all those magazines which are purchased and possessed after the effective date of the law. Under this law, there is a grandfather mechanism in it where you can maintain the possession of magazines that you own and possessed prior to the law going into effect. But even under Measure 114, there are very specific rules and restrictions on how those magazines can actually be used. Now, one of the major issues with Measure 114 and this whole permitting scheme was that once it went into effect on December 8th, it would have been next to impossible to even get that permit to purchase. As written in the measure, the process to acquire that permit was not even in place and would not exist maybe even at least until 30 days, which now we found out would be much, much longer. So that would have created a complete ban on the sale of firearms within the entire state of Oregon. In fact, the Attorney General in the state of Oregon sent out a letter pretty much admitting that they had no way to implement their scheme, and therefore they asked a federal court judge to put a temporary halt on the whole scheme from going into effect. That federal court judge did in fact grant only a 30-day temporary halt on the effective date of the permit scheme, but there was that other case, which is a state case, and that is the Arnold case. And in that case, a Harney County Circuit Court Judge, Robert Rocchio, granted an outright TRO, halting the permitting scheme and also the magazine ban from going into effect. Then later, he granted a preliminary injunction against the magazine ban, finding that it was a clear violation of the Second Amendment and also the Supreme Court's recent ruling and decision in Bruin. However, of course, the state of Oregon was not simply going to take their loss, lick their wounds, and go away. Instead, they attempted to get the background check portion of Measure 114 put into effect by asking the judge in that same case to lift the TRO to that one specific aspect of the law, being the background check. But we recently received an order from the judge, Judge Robert Roscio, denying the state of Oregon's request, and ultimately what he found is that the background check requirement in the law, in that Measure 114, is critically linked to the permit to purchase language, and essentially he found that there would be no way to separate the two and put only the background check into effect while also leaving the permit to purchase temporarily halted under the TRO. He found that separating the language of the permit to purchase and the background check would essentially mean that the permit to purchase language would be of no use, which of course, if you look at Measure 114, they are very critically linked, and you cannot say that one is not relevant and the other is relevant. And there really is no way to only put into effect the background check system, because the background check system is critically linked to the permit to purchase, because it's one of the requirements for you to get that permit to purchase, and that's where it's referenced. It's referenced in the section under the permit to purchase. He went on to state in his order that, further, only if the court holds the permit to purchase program unconstitutional will it consider severing the background checks under the ballot measures severance clause. So Judge Robert Roscio denied the state of Oregon's request that he lift the TRO to that one specific aspect of the background checks. Then something else really interesting happened in the federal court case, the OFF case. In that case, the state of Oregon, in fact, went to the federal court judge there in the case and asked the judge to postpone the enforcement of Measure 114 at least until March 8th. This was an interesting concession made by the state of Oregon, and again, it was essentially them admitting that they have no way to implement their new permit to purchase scheme, and that they would need at least until March 8th to get it up and running. And because the state of Oregon once again made that concession, the judge in the case had no choice but to grant that postponement. However, the judge in that case had to voice her own opinion and state that although the state of Oregon conceded that there is no way to implement the permit to purchase and that it should be postponed, she believes that it should not. She ordered, and she stated in her order that were this court to consider plaintiffs' arguments, however, it would nonetheless find that plaintiffs have failed to show a likelihood of success on the merits of any constitutional challenge to Measure 114's background check provisions. As discussed above, Justice Kavanaugh's concurrence in Bruin specifically stated that background checks, like the ones at issue in the instant case, are constitutionally permissible. Essentially, what she is stating in that order is that she believes that the permit to purchase and the background check scheme created in Measure 114 is in fact constitutional under the Bruin decision. However, she isn't going to make that determination at this time because the state of Oregon has essentially requested the postponement, but all indications are from that judge and her language and her prior actions in the OFF case is that once again, if she gets the opportunity to rule on the merits of the case, she will find that Measure 114 is constitutional. But for now, the state court TRO prevents the permit to purchase from going into effect and also has halted the background check system. Also, the federal court case has a postponement on the enforcement of the permit to purchase and background check at least until March 8th. The magazine ban portion of Measure 114 has a preliminary injunction issued against it, which essentially means that the enforcement of the magazine ban will not go into effect until this case is actually resolved. So that is where Oregon Measure 114 currently stands. If anything else develops, I will definitely let you all know. Also, if you like this video and you like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.